My lord, I may be pardoned to mention, my lord. Court number 7 assignment today matter may be listed, but due to non-function of the court, matter could not be listed, my lord. Auction is on tomorrow at 12 p.m., my lord. Erection dwelling house of the petitioner will be on the street, my lord. As the last matter may be taken, or at 12:30, my lord, matter may be taken.
We'll see that. We'll see. If say Kali ki list kare diyo some matter. Yes. Next.
I have one matter of court number 7, Your Lordship. Here in this under the Surface Act, that physical possession has not been taken, but ejection has been taken. But pursuant, I have approached to this fellow in a writ petition. But pendency of writ petition, the bank manager said that you paid that amount, the auction value amount paid, will release that property. I paid that amount. Subsequent did not cooperate.
Give it will be listed tomorrow. Yes. Yes.
Supplemental list item number 1.
Wrongly correction. Only 11. It was posted to 11:3. Penali pen diyo. But 11th February is na. Aaya. लिखी देवे तो correction हले reading by scoring it होला. हम कोई use it let the other format that it is pour out and corrected line open and corrected one be uploaded also. So we upload them. The copy of the order be communicated to the court who communicate for the and say date advance for you. Learning judge family court खुदा है ना. By the registered judicial court during course of the day for the. Yeah. Attorney.
Weekly list passover item number 4.
May it please your lordship.
Modification.
Mad modification at twofold. Your lordship will kindly peruse the order that was passed.
No, what modification?
But there was erroneous mentioning of the plot number instead of 51, it was mentioned as 15. Though, my lord, your lordship will find from the document enclosed to the writ petition, in fact, the allotment in favor of the petitioner was 51. But that is one error. The other one, my lord, is revenue plot number 51 PT. That is in fact 57. 57 SCR.
Mr. Das.
There is one development. I must assist your lordship.
Correction.
May I assist your lordship on one development? Here also your lordship was used to direct that I should file an undertaking. My lord,
this is only come for correction. No, we will not touch the other part of it.
No, yes. I am not saying that I will not give undertaking. I am only praying, my lord, because they have said I had given the undertaking immediately. They said that you have not given the undertaking. Therefore, I have prayed for extension. I am ready because your lordship said the front portion I should vacate. The backland is to be allotted.
Development made in the meantime might have been.
This is the development only.
No, bring it by where no.
I have given my friend a copy of that also. এই যে অর্ডারটা হয়েছে যে জেসে কইলে যে আন্ডারটেকিংটা দেই নুল
Because if that order has been already acted upon,
But they have not said plot number incorrect. They have only said undertaking not filed. Therefore, I have prayed before that for extension of time.
we dispose of with a direction
My lord,
and gives an undertaking before
my
the authority, he will hand
this
over the
petition was filed on
portion of this one. So if not already handed over in such even the authorities are एटा आनंद से operative portion रे कौन किसी वर्तमान ये है
As per the order, my lord, last year, now therefore the
only
prayer for the
undertaking done.
SAHOO for allotment of the additional land measuring so and so adjusted to his plot on the backside is rejected solely on the ground of his non-submission of the required undertaking in this department pursuant to the order of the Honorable High Court dated 30.
So that you are to file for modification of that order.
And that also I have prayed for, my lord. Time limit
No,
in the prayer portion.
That very order is to be annexed because we cannot. It would be if any clerical mistake is there, we can correct. But that party is concerned, you have to file a separate application so that
I will file
development, if any, also in the meantime also.
But that I have also brought to my friend's notice.
1615
But I cannot withhold this fact.
2020, there is an application for modification of the order dated so and so. After hearing the learned counsel for both the parties, we are just correcting that plot number and this. So correction, correction, and time limit direction and time limit fixed for giving undertaking.
Only on the ground of time undertaking.
जहाँ भी हो that
When your IA was pending.
ତେଣୁ ସେ part ଟାକୁ ସବୁ
There is a separate IA ନେଇ ଆସିବି ଆଉ. My lord has been pleased to observe. I have to file a separate IA.
Right. So edita ଜିନିଷ ହେଇଯିବ. So the plot number as mentioned in the order dated so and so be read as plot number 51 of 1605 in place of so and so, and the revenue plot be read as 57 Jahar election so and so. Mr. Mishra Land Council for submits that there has been some development in the meantime, and he want to file a separate interim application for appropriate relief. Accordingly, the IA is disposed of for them.
Grateful, my lord. Grateful, my lord.
Item 9.
May please, Lordship. What is this report regarding present whereabouts of the appellant yet to be received? What upon noting in the cause list.
Madam, they reach the status report. Because these are just submitted reports direction. No, not just for that, but rest will telephonically for London Council who appears on the staff and appoint for Mr. Sushant Kumar, he appointed the Naruto for that, that is the director to separate about
Next, कौन है लासे लोगों को पहुंची तो?
नहीं गुप्ते मोर ये
Appellant number 3.
That
was
10 to 12.
Paper book, give it the paper. You said Sunia Munda is dead.
Yes, ma'am. 10 to 12 years ago.
Where is that report?
The report is yet to be received. That is the notice. That
see-
may not be on record.
ସେଇଥିପାଇଁ ପଚାରୁଛି
ନା ଆର ଡେଟ୍ରେ ଦେଇଥିଲି
ଦେଇଥିଲେ ଆପଣ?
ୟେସ୍
ଦେଇଥିଲେ ଗଲା ତ। ସେଟା ଏଥିରେ ଲାଗିବ ନା, ସେ ଯୋଉ ଲାଗିବ ଏଟା। ଆଉ ତା ଭିତରେ copy ହେଇକି ନେଇପାରିବ। କାଳେ ୟା ଭିତରେ ପଶି ଯାଇଥିବ ବୋଲି କହୁଥିଲେ।
ଆପଣଙ୍କ ପାଖରେ ଇଏ ନାହିଁ କି କପି ନାହିଁ କି ଦେଇ ଦଉନାହାନ୍ତି ତାର ଗୋଟେ କପିଟେ ଇଏ କରି ଦିଅନ୍ତୁ
ଯୋଉ ଆପଣଙ୍କ ପାଖରେ ଥିବ
ସେଠିକି ଯାଆନ୍ତୁ
ପ୍ରିଣ୍ଟ ଆଉଟଟା ବାହାର କରନ୍ତୁ
ଗୋଠୁ ଯାଆନ୍ତୁ ସେ ଫାଇଲ ନେଇକି ଯାଆନ୍ତୁ if he has given a copy then you should have put the seal mark and keep it The other day you submitted that there are no eyewitnesses to the occurrence. It's a case based on circumstantial evidence.
yes that's true
And one is the last scene, which is deposed to by 5 witnesses.
4, 5, 9, 10, 11.
Right?
Lots of
And then the other part is the motive.
yes
PW10 stated. These are all the circumstances.
yes these are the only circumstances
Because the weapon of offense, that is the stone that was lying at the spot. Now, so the main thing is about these 5 witnesses last scene.
yes
And we pointed out one decision of the Honorable Supreme Court where number of decision has been taken into account. That is 2017 volume 14 SCC 359 Anjan Kumar Sharma versus State of Assam. Se bohi anicho? Okay. Now, and we saw the evidence of PW10. From that, it doesn't appear that there is any clinching motive because that from the police station, one of the appellant had brought that notice, which is to be served on the other 2 appellants. And he came to the Gramraki. Gramraki means the appellant, deceased. Deceased said, you go and call them. Then perhaps he did not come, so this deceased again went. Then all the 3 came. They took some food as well as some liquor.
yes
Then they went away. So it was as it appears from the evidence of even the wife that it was almost a cordial relationship. There was no motive behind. That's why we say that the motive was missing on the front. But one thing has brought from the evidence of the IO that notice was only meant to produce Katemunda. That is in paragraph number 4. That document has been exhibited as 7/2, which was not there. That's why we called for the original. The original data 7/2 ta bar kar do. লেখা যেত না ତମେ ସାଙ୍ଗେ ସାଙ୍ଗେ ଏଇଟା ହଉଛି ସେ ଯୋଉ ଇଏ ନା ଡିସିଜ ନା ତମେ ସାଙ୍ଗେ ସାଙ୍ଗେ କାଟେ ମୁଣ୍ଡାକୁ ସାଙ୍ଗରେ ଧରି ଆସିବ ତାଙ୍କୁ ଡାକିବ ଥାନାକୁ ଆସିଲେ ସମାଧାନ କରିଦେବା ଏଇଟା ହଉଛି ଗୋଟେ କଣ ଲେଖା ହେଇଛି what is the name of the deceased
କେଶବ
केशव चंद्र पात्र
This is Kesava
पात्र
केशव लेखा जाओ केशव तमे सांगे सांगे काटे मुंडा को सांगरे धरी आसीबो ताकू डाकिबो थाना को आसिले समाधान कर देबा. So there was no intimation to call the both the other two appellants because the prosecution is relying on this particular document that on that day all the three appellants along with the deceased they went together because there was notice from the police station, but the notice itself shows that it was only meant for Kate Munda. Kate Munda is already dead. So that was Sonia Munda alias Kate. So that was not meant for this other two Mangra Munda and Gobra Munda. And PW 4, 5 and 9, 10, 11. Let us just read once again because then we will. Come to PW 4, page 29.
शक्ति पात्र
সেটা করবে সেটা କରିଦେଇକିନି ଏଇଠି ସିଗ୍ନେଚର ହେଇକିନି ଫାଇଲଟାକୁ ନେଇକିନି ରେଜିଷ୍ଟର ଜୁଡିସିଆଲକୁ ସେ କମ୍ୟୁନିକେଟ କରିବ କାରଣ ସେ ଡେଟ୍ ତାଙ୍କର ଥିଲା 26 ଆମେ ତ ଆଡଭାନ୍ସ କରେଇକିନି ଆସନ୍ତା ସପ୍ତାହକୁ ରଖିଛୁ ଗୋଟେ ପୂଜା ହେଲା. Yes.
PW4 Shakti Patra matter.
କଣ
I know the informant of this case.
go slowly. Yes.
Proceed. I know the informant of this case. I do not know the accused person standing in the dock. I know the deceased Keshav Patra who was working as village chowkidar. The occurrence took place about 5 years back near village Chandipos. On the date of occurrence, at about 3 p.m., when I, along with other co-laborers, were carrying the wedding operation in my land, at that time I found that deceased was taking 3 persons towards Koida, and also mm, uh, and also heard that these three heard that those 3 persons were quarreling with the deceased in loud voice. I cannot say which village these persons belongs to. The road along which the deceased and the said 3 persons were going is at a distance of 70 to 80 cubits away from the place where we were carrying wedding operation. The said road leads to Koida through village Chandipos. On the following day, I heard that deceased was killed, being assaulted on his head by means of a stone. Cross-examination of the defense. I was examined by the IO after 1 month of occurrence. I have not disclosed to any of my family members regarding the quarrel took place between deceased and the 3 persons while they were passing on the road. Chandipos is at a distance of 1 kilometer from our village. The dead body of the deceased was lying at village Chandipos. The voice from the road is not audible from our land where we were engaged in wedding work. It is not a fact that I am deposing falsehood at the instance of the police.
So 2 things, Mr. Tripathi.
Yes.
We find that if he didn't know the accused persons, then from his evidence at least it cannot be said, if we take his evidence alone, that the persons who were in the company of the appellant, on the company of the deceased on that day were the appellant, right? Number 2, about the quarrel between the appellant and those 3 persons.
Yes.
He stated to have heard it, but again says that the voice from the road is not audible. So that is also another feature that about that he heard some quarrel, that is also doubtful. So this is so far as PW4 is concerned. That means PW4's evidence is, if it is considered in isolation, then it is the identity of the appellants are not established because he did not know the appellant, right? And now we will come to the next witness, that is PW5. Though the 161 indicates that it was on the day of presentation of the FIR. আমি সেদিন দেখিଥିଲି তার কোন তা নাটা
শক্তি পাত্র
শক্তি
শক্তি SATI
SATI শক্তি 5-10-2019 রেকর্ডিং সেইদিন FIR ହେଇଛି 4-10 FIR 5-10 ହଁ next day ପକେଇ ଦେଇଛି ଇଏକୁ ବି ଗାଁରେ ପଡୁଥିଲା PW4 ଗୋଟେ ଗାଁ Okay, now we'll come to PW5.
Padma Patra. I know the informant of this case. I know the deceased Keshav Patra, who is working as police staff. I know the accused person standing in the dock. The occurrence took place about 4 to 5 years back. On the date of occurrence, I, along with PW4, carrying out wedding operation work in the field of PW4. I was engaged as a laborer to do the wedding work. At about 12 noon, I saw that the deceased was taking 3 persons towards Koida PS, and they were going through the road which leads towards Koida PS. 3 persons were quarreling with the deceased in loud voice. The witnesses identified the accused persons in court. These accused persons were quarreling with the deceased while they were being taken to police PS by him. The accused persons were working as laborer with me at the mines. After finishing the wedding work, I went to my house at about 4 p.m. On the next day, I heard that somebody has killed the deceased and his dead body was lying on the side of the road which leads to Koida.
No, time, even if timing is also little different. From PW4 କହିଲା 3ଟା ବେଳେ ଆଉ ଇଏ ଯୋଉ PW5 କହୁଛି 12ଟା ବେଳେ କାରଣ ଦି ଜଣ ଯାକ ଏକାଠି କାମ କରୁଥିଲେ ନା ହେଲା
And also there is a mismatch regarding where the dead body was lying. PW4 is saying it was lying at a village Chandi post, whereas PW5 has stated it was lying
Leads
near
to
that road. Dead
lying
body
by the
was
side
lying
of the
by the side of the road which led to Koida.
leads to Koida.
So there is a
Okay, next, I come to the cross examination.
I used to go to my work in the morning hour and return home in the afternoon. I have no prior acquaintance with the accused persons. The land in question where we are taking the wedding operation is at a distance of 1 furlong from the road. Even if somebody shouts loudly on the road, it is not audible to the place where we were working. It was raining by then. It is not a fact that I have not heard the noise. The deceased was distantly related with me as nephew. It was not a fact that I am not engaged as laborer on that day and was not carrying any work in the field of PW4. It is not a fact that I am deposing falsehood.
No, ଏଇ ଯୋଉ ଜିନିଷଟା ଲାଇନଟା କହିଲା second sentence of cross examination. I have got no prior acquaintance with the accused persons. Is it not going contrary to the statement made in the chief examination that the accused persons were working as laborers with me at the mines?
Mines.
ତେଣୁ ତା ସାଙ୍ଗରେ acquaintance ନଥିଲା ଏମାନଙ୍କ ସାଙ୍ଗରେ ତାମାନେ ଯଦି କ୍ରସ୍ ଏକ୍ସାମିନେସନ କୁ accept କରାଯିବ, that means on the first point of time he saw them on that day.
Yes.
Okay, and then in court
Identified.
in court. So in such circumstances, whether question would be that whether there was necessity of conducting TI parade or not, because if he is not a known person, seeing them for the first time identifies in court, then it should have been a TI parade would have been done. Test identification ଏଇ ମାନେ ଥିଲେ ବୋଲି ଯେତେବେଳେ arrest ହେଲା test identification parade ହେଇଥାନ୍ତା ଯୋଉଟା link କରିଥାନ୍ତା
161 ରେ କହିଥିବ ବୋଧେ
161 ଆପଣଙ୍କର statement that is not the substantive piece of evidence. ବର୍ତ୍ତମାନ କୋର୍ଟ ରେ ଆପଣ କହୁଛନ୍ତି ମୋର ତା ସାଙ୍ଗରେ କିଛି ଜଣାଶୁଣା ନଥିଲା, ଚିଫ ରେ କହିଲେ ଆମେ ସାଙ୍ଗ ହେଇକିନି ମାଇନ୍ ରେ କାମ
କାମ
କ୍ରସ୍ ଏକ୍ସାମିନେସନ ରେ କହୁଛନ୍ତି ପ୍ରାୟର
Acquaintance କିଛି ନାହିଁ।
ଟୋଟାଲ ନଥିଲା। ଯଦି ଏଇ circumstance ରେ ଦିଟା contradictory statement ଆସୁଛି, then which one is to be believed? Then if the second statement is accepted, then it cannot be said that court identification for the first time. Now timing difference ଆସୁଛି 12ଟା ବେଳେ ଆଉ ଇଏ ବେଳେ ଇଏ 3ଟା ବେଳେ। ଆପଣ ଯଦି ଏ statement ଟାକୁ consider କରନ୍ତି ଯେ I used to go to work in the morning and return home in the afternoon. If that is the state of affair, then he would not be present at about 3 o'clock, which has been stated by PW4. ଯଦି ଏଇ ଟାଇମଟା ହୁଏ 3ଟା ବେଳେ ସେମାନେ ଆସୁଥିଲେ ଏବଂ ସେତେବେଳେ ହିଁ ଏମାନେ ଦି ଜଣ ଯାକ ଦେଖିଲେ। PW4 has not stated that he was working with PW5. Has he stated?
ନା ସେ କହୁଛି I along with other co-laborer. Who are they? He had not named.
So PW file no prior acquaintance. It contradicts the version in chief. And again, that same thing, like that, not audible. So ଆପଣ ହଁ PW4 ଆଉ ୟାର ଦି ଜଣଙ୍କର ଭର୍ସନ ମଧ୍ୟ ସମାନ ଅଛି ଯୋଉଠି ସେମାନେ କାମ କରୁଥିଲେ ଏଇ ଯୋଉ କଳି କଥାଟା ଆପଣ କରିକିନି ଗୋଟେ ଆଣୁଛନ୍ତି ତାଙ୍କ ଭିତରେ କଳି ହେଇଥିଲା ହୁଏତ ସେଇ କଳି ପାଇଁ ମାରି ଦେଇଥିବେ କିନ୍ତୁ ତାଙ୍କ ଭିତରେ କଣ ହଉଥିଲା ଏଠୁ ଶୁଣା ଯିବନି ବୋଲି ଆସିଲା. So this is the evidence of the two witnesses. Now we will go to the other three, that is 9, 10 and 11. So come to 9.
Mohan Charan Das.
Yes.
I know the informant of this case. I know the accused person standing in the dock. I also know the deceased Kesapatro, who was the Gramaraki. The occurrence took place one day in the month of October in the year 1999. At the relevant time, I was working as mines supervisor in the office of mines at Patmunda. On the earliest date of incident, at about 11 a.m., the deceased came to me being a complaint by being accompanied by accused persons and approached me to provide a dumper so as to carry the accused persons to Koida PS, as they were required by the police. But I expressed my inability to provide the dumper as there was no availability of the dumper. Then they all left. At about 3:30 p.m. on the same day, while I was coming to Koida with a water tanker on the way near Baldihi, I found that the deceased, along with the accused persons, were moving towards Koida, and seeing them, I called them to go in the said tanker, but they did not agree and told me to go by walk. Then I left for my destination. On the next day morning, while I was going from Koida to Patmunda in a commander, I heard that the deceased had been killed and the dead body was lying by the side of the road near Baldihi. Cross-examination. I am the permanent resident of village Talkoi. I was attached to my office as supervisor. As per instruction of Mongara manager, I used to alert the vehicles for their operation. I have been serving at Koida since 1994. I am not acquainted with the local inhabitants. I know the accused persons since their brothers were working in our mines. It is not a fact that I had no acquaintance with the accused persons. The vehicle distributions register is maintained by the manager. I cannot say the same of I cannot say the name of the father of the accused persons. I cannot say the number of their family members. I cannot say about the vocation of the accused persons. It is not a fact that the deceased has never approached me for a vehicle being present along with the accused persons. It is not a fact that I am deposing falsehood.
Okay, come to PW Payne. He is the son of the deceased.
Yes, son of the deceased.
And the informant also.
Yes.
No, he's
No,
not the informant.
he's not the informant.
Informant is PW3.
Yes.
I know that.
Fakir Mohan Patra.
Yes.
I know the informant of the case. I know the accused person standing in the dock. The deceased Kesab Patra is my father. The occurrence took place on 3/10/1999 at village Baldihi roadside. My father was working as a Gramaraki. On 2/10/1999, my father had received a notice from Koida PS to take the accused persons, namely Kate and Gobara to the PS. On the next day, my father went to village Podadihi and came back to our house along with all accused persons at about 1 p.m. Thereafter, my father took his meal and accused persons drank handia, being served my mother. Then they all left for Koida PS, including my father. On the next morning, I got the information that my father was lying dead by the side of the road near Baldi village, and getting information, I rushed to the spot and found my father lying dead with bleeding injuries on his head. Then police came to the spot and held inquest over the dead body of the deceased in my presence and prepared the inquest report. Then this is the said inquest report which is now marked as Exhibit 11, and Exhibit 11/1 is my signature thereon. Cross-examination. Our village is at a distance of 3 kilometers away from village Podadihi. The accused persons are resident of village Podadihi. At about 11 to 12 a.m., the IO held inquest over the dead body. Then the dead body was sent for PM examination to Koida Hospital. I also accompanied with the dead body. I returned to my house in the evening. On the same day, I was examined by the IO at the spot before my visit to hospital. I have not read contents of the notice. I have not seen the notice. Later on, I came to know the contents of the notice. It is not a fact that nobody had given any notice to my father, nor my father went to village uh, Podadihi to call the accused persons. It is not a fact that I have not seen the accused persons along with deceased, and that I am deposing falsehood.
Yes.
11. Wife of the deceased.
Wife of the deceased.
I know the informant of this case. I know the accused person standing in the dock. The deceased Keshav Patra was my husband. The occurrence took place about 5 years back at about 3:30 p.m. at Baldihi. On the alleged date of occurrence, the accused Mangara Munda came to our house in the morning with a notice from Koira police and delivered it to my deceased husband. Then my deceased husband told the accused Mangara to go to village Podadihi to call other two accused persons as they were required by the police as per the notice, since a quarrel had taken place between the accused Mangara Munda on one side and other two accused person on the other side. After a while, after taking tea, my deceased husband left the village Podadihi to call the accused persons. At about 3 p.m., my deceased husband came to our house along with the accused person and instructed me to serve them food. On being instructed, I served country rice beer and one plate of chicken to the accused person. After taking their meal, the accused person, being accompanied by my deceased husband, went towards Koira PS. While they were proceeding towards Koira police station, at the place of occurrence under a banyan tree, the accused Sonia Munda and accused Gobra Munda, who were brothers, assaulted my deceased.
This he has not seen.
No.
I have, and the cross-examination of the first line, paragraph 5, that I have no direct knowledge about the occurrence.
Yes.
Baki,
About the notice and last scene. This part.
Notice ta Mr. Tripathi.
Yes, sir.
Notice is very clear. Notice ta hochi 2/10/19 notice OIC se jo ଦେଇଛନ୍ତି ଏବଂ ଇନଷ୍ଟ୍ରକ୍ସନ ଅଛି ଡିସିଏସ୍ କୁ ଯେ ତମେ ସାଙ୍ଗେ ସାଙ୍ଗେ କାଟେ ମୁଣ୍ଡାକୁ ସାଙ୍ଗରେ ଧରି ଆସିବ, ତାକୁ ଡାକିକିନି ଥାନାକୁ ଆସିଲେ ସମାଧାନ କରିଦବା। ଏଇ ଯୋଉ ୱାଇ ଏଇଟା ଆଣିକିନି ଦେଇଛି, ତା ପରଦିନ ସେ ତା ସ୍ତ୍ରୀ କହୁନି କି
Mangara Munda is one side and Kate Munda and his brother is the other side. They were
yes. जे on the alleged date of incident, माने 3 तारीख दिन.
Yes.
3 तारीख दिन accused Mangara Munda came to our house in the morning with a notice. This ए जो notice टा
Mangara Munda
2 तारीख रो ताकू Mangara Munda धरिकिने आसीथिला from Koira police station and delivered to my deceased husband, है ना?
Yes.
My deceased husband told accused Mangara to go to village Pododihi to call the other Podadihi to call the other two accused persons. That they were required by the police. Ethi notice कहूनी जी आरो accused को, but गोटे को कहूची. Since quarrel had taken place, you know, कौड़ी ହେଇची का भीतरे ना
Mangara Munda and
right.
two accused.
Right.
So why they will kill together to the
Deceased.
deceased.
हाँ,
If there is a quarrel between Mangara and other two accused persons, together the allegation is together they killed the deceased.
Yes.
because Mangra Munda, you see, Mangra Munda's cause is being assisted by the appellant,
Yes.
the deceased. କାରଣ ମଙ୍ଗରା ମୁଣ୍ଡା ର କେସ୍ କଲା, ନୋଟିସ ଟା ଆଣିଲା ଥାନାରୁ, ଆଣିକିନି ହାବିଲଦାରକୁ ଦେଲା, ହି ଯିଏ ହଉଛି ଡିସିଜ ତାକୁ କୋଅପରେଟ କରୁଛି ଏବଂ ଘରେ ଖାଇକିନି ଏମାନେ ଯାଉଛନ୍ତି। ତେଣୁ there would not have been any kind of motive on the part of the appellant। ଆର ଦିଟା accused ର ଗୋଟେ accused ବି accompany କରିବା ବି doubtful ହଉଛି because
Both are brothers.
କିଏ
1, 2.
1, 2.
that is all right, but notice is meant for only
Meant for one.
PW3 and
Let us say that
Sorry.
in spite of the notice, both are going.
Yes.
Question is that why they would this motive, why there would be any kind of grievance against the, କାରଣ ସିଏ ତ ଏଠି କହୁନି ଯେ ଆମେ ତାଙ୍କୁ ଆରେଷ୍ଟ କରିବୁ, ସେ ଖାଲି ଡାକିଛନ୍ତି ତା ଭିତରେ ସମାଧାନ କରିବା ପାଇଁ। କଳିଟା ହେଇଛି, ଇଏ ନୋଟିସ ଟା ଆଣିଛି, ସିଏ ନେଇକି ସମାଧାନ କରିବ। there is no compulsion। ସେମାନେ ଆସିଲେ ଘରେ ଖାଇଲେ, ଇଏ ତାକୁ ୱାଇଫ କହୁଛି ଯେ ମୁଁ ତାଙ୍କୁ ମଧ୍ୟ I served rice, beer and 1 plate of chicken।
Yes.
ତାଙ୍କୁ ଖାଇଲେ ଏବଂ ଖାଇଲା ପରେ ସେମାନେ ସାଙ୍ଗ ହେଇକିନି ଗଲେ। ତ in such a situation, what can be the motive on the part of the appellant to commit the crime? And that is relevant because it's a case based on circumstantial evidence. And if the only evidence is this last scene,
Yes.
so the law is that it is very risky in such a situation। କାରଣ ଯାହା ବି ହଉ ଆପଣଙ୍କର maximum ଯଦି କିଏ କହୁଛି let us say କିଏ କହୁଛି 12ଟା ବେଳେ ଦେଖାଗଲା, କିଏ କହୁଛି 3ଟା ବେଳେ ତାଙ୍କୁ ଦେଖାଗଲା। ଏଇ ଯୋଉ ସ୍ତ୍ରୀ ଲୋକଟି ଯଦି ଆମେ 11ଟା PW11 କୁ ଦେଖିବା, ତାହେଲେ ଯାହା ଘଟଣା ୟା ଟାଇମିଂ ଯଦି ଦେଖାହବ, ଘଟଣା ମାନେ 3ଟା ପରେ ସେମାନେ ସାକ୍ଷୀ ହେଇଯାଇଛନ୍ତି। And so at about 3 PM my deceased husband came to our house along with the accused persons and instructed them। ତାପରେ ସେମାନେ ଖାଇଛନ୍ତି। On being instructed, I served the food, rice, beer, 1 plate of chicken, so on। After taking the meal, ତେଣୁ ଯାହା ବି ହେଇଥିବ 3ଟା ପରେ ହେଇଥିବ। ତେଣୁ ଯିଏ ନୁନ ରେ କହୁଛି ଯେ ମୁଁ ଦେଖି
PW5 ନୁନ କହୁଛି, PW4 4ଟା କହୁଛି।
ହଁ, PW ଯିଏ ନୁନ କହୁଛି ସେଟା ବିଶ୍ୱାସ ଯୋଗ୍ୟ ହବନି, କାରଣ ଏମାନେ ତ ଘରୁ ବାହାରିଲେ 3ଟା ବେଳେ। ତେଣୁ ଯାଇ ସେଠି
No. This case is, these persons are rustic villagers,
They
labor
have-
class and illiterate.
they have rather very good sense of time। ସେମାନେ ସୂର୍ଯ୍ୟ ଦେଖିନି କହିଦେବେ ବର୍ତ୍ତମାନ ଅନ୍ଦାଜ କେତେ ହେଇଥିବ। ଆପଣ that they have got a that type of assessment। ଏଠି ଗଲା, ଏଠି ବର୍ତ୍ତମାନ ପ୍ରାୟ ଏଇ ଯୋଉ ଜିନିଷଟା କହୁଛନ୍ତି ନୁନ ମାନେ ସେମାନେ ଭାବିବେ ସୂର୍ଯ୍ୟ ବର୍ତ୍ତମାନ ଏଠି ଅଛନ୍ତି। ସେମାନେ ସୂର୍ଯ୍ୟ ଯେତେବେଳେ ଯାଇ ସେପଟରେ ପହଞ୍ଚିବ, ସେମାନେ କହିବେନି ଦିନ 12ଟା ହେଇଛି, କାରଣ ସେମାନେ ସକାଳୁ ଯାଇଥାନ୍ତି ବିଲକୁ, ଆସନ୍ତି କାମ କରିକିନି ସେ 12ଟା ଘଣ୍ଟେ ବେଳକୁ ଆସନ୍ତି, ଗାଧୁଆ ପାଧୁଆ କରନ୍ତି, ଖାଇ ପିଇ ଶୁଅନ୍ତି, ରେଷ୍ଟ ନିଅନ୍ତି, ପୁଣି 4ଟା ବେଳକୁ ଯାଆନ୍ତି ଆଉ ଟିକେ ଦେଖିବା ପାଇଁ ଯଦି କାମ ଥାଏ। ଦ୍ୟାଟ ଇଜ ଦି ସେମାନେ ମଧ୍ୟ ସେଇଆ ଏଭିଡେନ୍ସ ଦଉଛନ୍ତି ଯେ ଆମେ ସକାଳୁ ଯାଉଛୁ, ପଳେଇ ଆସୁ ଇଏରେ। ତେଣୁ ଆଫ୍ଟରନୁନରେ 3ଟା ବେଳେ ସେମାନଙ୍କର ପ୍ରେଜେନ୍ସ ଆଟ୍ ଦ୍ୟାଟ ସ୍ପଟ, ଦ୍ୟାଟ ଇଜ ୱାନ୍ ଥିଙ୍ଗ। ଆଉ ଯିଏ 12ଟା ବେଳେ କହୁଛି, 12ଟା ବେଳେ ସମ୍ଭବ ନୁହେଁ, କାରଣ 3ଟା ବେଳ ପର୍ଯ୍ୟନ୍ତ ତାଙ୍କ ଘରେ ଥିଲେ, ତାପରେ ଖାଇଛନ୍ତି, ତାପରେ ଆସିଛନ୍ତି। ଇଏ ଗୋଟେ ଜିନିଷ। ଦ୍ୱିତୀୟ କଥା ହଉଛି about the motive behind the commission of the crime। ତାପରେ ଟାଇମ ଗ୍ୟାପ ଦେଖନ୍ତୁ, ଆପଣଙ୍କର ଯୋଉ ଜାଗାରେ ସେମାନେ ଲାଷ୍ଟ ଦେଖା ହେଲେ ସେଇ 3ଟା ବେଳେ, ଆପଣଙ୍କର ସେ ଯୋଉ ତା ମାଲିକ ଯୋଉ କଣ ସେ ମାଇନ୍ସ ସିଏ
PW
ସିଏ ବି
9
ସେଇ 3ଟା ବେଳେ କହୁଛି
3:30
ହେଲା, ସେଇ 3:30। ଡେଡ ବଡି ମିଳିଲା ତା ପରଦିନ 9ଟା ବେଳକୁ ବୋଧେ ମିଳିଲା ନା,
9ଟା ବେଳେ
ସେଟା ଦେଖୁଛି କିଏ
PW3
3
informant।
ତେଣୁ ଗୋଟେ ଜାଗାରେ ସେମାନେ ଦେଖା ହେଲେ 3ଟା ବା 3:30 ହଉ, ଏବଂ ଆଉ ଗୋଟେ ଜାଗାରେ ସେମାନଙ୍କର ଡେଡ ବଡି 9ଟା ବେଳେ ମିଳିଲା। ତେଣୁ ଏଇ ଦ୍ୟାଟ ଇଜ ଦି ଓନ୍ଲି ସରକମଷ୍ଟାନ୍ସ। ତେଣୁ very weak in view of the ସେଟା ବହିଟା ଦବା ସେ ଯୋଉଟା ଡିସିସନଟା ଯୋଉଟା ସୁପ୍ରିମ SEC ର that is reported in 2017 volume 14359. The circumstance of 19 paragraph. Class in together cannot by itself form the basis of holding the accused guilty of the offense. In Kanhaiyalal versus State of Rajasthan, 2014 4 SCC 71, the circumstance of last seen together does not by itself and necessarily lead to the inference that it was the accused who committed the crime. There must be something more establishing connectivity between the accused and the crime. Mere non-explanation on the part of the appellant, in our considered view, by itself cannot lead to the proof of guilt against the appellant. The theory of last sin, the appellant having gone with the deceased in the manner noticed herein, is the singular piece of circumstantial evidence available against him. The conviction of the appellant cannot be maintained merely on suspicion, howsoever strong it may be, or on his conduct. These facts assume further importance on account of absence of proof of motive, particularly when it is proved that there was cordial relationship between the accused and the deceased for a long time. That situation is so and so. In Arjun Malik state of Bihar, 94 CC, that the evidence of the appellant had gone to Sitaram in the evening of so and so and had stayed in the night house of the deceased. Sitaram is very shaky and so on. Even it is accepted that they were there, it would be at best amount to the evidence of the appellants having been last seen together with the deceased. But it is a settled law that the only circumstance of last seen will not complete the chain of circumstance to record a finding that it is consistent only with the hypothesis of guilt of the accused, and therefore no conviction on that basis alone can be founded. So and so, failure of the accused to offer any explanation in his statement under section 313 CRPC alone was not sufficient to establish the charge against the accused. In the facts of the present case, the High Court committed an error in holding that in absence of any satisfactory explanation by the accused, the presumption of guilt of the accused stood unrebutted and that the appellant are liable to be convicted. In so and so, the submission of coupled with the lack of satisfactory explanation by the accused is very strong circumstance on the basis of which accused can be, it was held that it is true that in case of circumstantial evidence, not only should the various links in the chain of evidence be clearly established, but the completed chain must be such as to rule out reasonable likelihood of innocence of the accused. But in a case like this, where the various links as stated above have been satisfactorily made out and the circumstances point to the appellant as probable assailant with the reasonable definite and in proximity to the accused as regard the time and situation, and he offers no explanation, which if accepted though not proved would afford a reasonable basis for a conclusion on the entire case consistent with the innocence, such absence of explanation or false explanation would itself be an additional link which completes the chain. We are therefore of the view that it is clear from the above that in a case where the other links have been satisfactorily made out and the circumstances point to the guilt of the accused, the circumstance of last seen together and absence of explanation would provide an additional link which completes the chain. In the absence of proof of other circumstances, the only circumstance of last seen together and absence of satisfactory explanation cannot be made the basis of conviction. So this is the consistent. So many decisions the lordships have taken into account, and ultimately, yes, they have been acquitted the appearance. So here, except the last sin, which is also of this nature, there is nothing else, and he has denied it that this. Yes, Mr. Tripathi.
Yes, madam. The burden lies on the petitioner, Millard, to explain
No,
how they are parted. They have last seen,
no.
and that
First of all, let us say that he has explained, the prosecution has proved last seen, and it is also, let us accept that when such questions were put in the 313 CRPC statement, he simply denied it. Question is that whether on that basis alone the appellants can be held guilty or not. The decision which has been said that if there are other links which completes
the chain.
ସେଟାକୁ ପଏଣ୍ଟ ଆଉଟ୍ କରୁଥିବ ଗିଲ୍ଡକୁ, ତାହେଲେ ଏଇ ଯୋଉ ଲାଷ୍ଟ ସିନ୍ଟା ଗୋଟେ ଆଡିସନାଲ ଲିଙ୍କ ହିସାବରେ ନିଆଯିବ, ଯୋଉଠି ଆଉ କିଛି ନାହିଁ, only on the basis of last sin you should not convict. That is, even if he has, whether he has offered explanation. ଆଉ ଥରେ ପଢୁଛି ଦେଖନ୍ତୁ, this Anjan Kumar Sharma, it is clear that in a case where other links have been satisfactorily made out and the circumstances point to the guilt of the accused, the circumstance of last sin together and absence of explanation would provide an additional link which completes the chain. In the absence of proof of other circumstance, the only circumstance of last sin together and absence of satisfactory explanation cannot be made the basis of conviction. Clear? Different here. ତେଣୁ ଏଠି ଆପଣଙ୍କର ଆଉ କିଛି ଟୋଟାଲି ହିଁ ନାହିଁ, ଖାଲି ଗୋଟିଏ circumstance, ସେଇଟା ହଉଛି last sin. Last sin ଲେଖା ହେଇଛି, କିଏ କହୁଛି 12ଟା ବେଳେ, କିଏ କହୁଛି 3ଟା ବେଳେ ବା 3:30 ବେଳେ, ଯାହା ବି ହଉ, ତାହା ପରଦିନ ସକାଳ 9ଟାରେ ଡେଡ୍ ବଡି ଆଉ ଗୋଟେ ଡିଫରେଣ୍ଟ, ଆପଣଙ୍କର ଯୋଉ ଜାଗାରେ ଲାଷ୍ଟ ସିନ୍ ହବ ସେଇ ଜାଗାରେ ଯଦି ଡେଡ୍ ବଡି ମିଳିବ, ଦ୍ୟାଟ୍ ଇଜ ୱାନ୍ ରେଲେଭେଣ୍ଟ ଫ୍ୟାକ୍ଟର, କିନ୍ତୁ ଗୋଟେ ଟୋଟାଲ ଆଉ ଗୋଟେ ଜାଗାରେ ମିଳିବ, then what happens, the chance of somebody else coming in between in contact with the deceased cannot be ruled out. ସେଇଟା ମଧ୍ୟ ଏଠି କହୁଛନ୍ତି, ଗୋଟେ କୋଟ୍ କରିଛନ୍ତି, the time gap between the accused persons seen in the company of the deceased and the detection of the crime would be a material consideration for appreciation of the evidence and placing reliance on it as a circumstance against the accused. But in all cases, it cannot be said that the evidence from the principle laid down above, the circumstance of last sin would normally be taken into consideration for finding the accused so and so when it is established by the prosecution that the time gap between the point of time when the accused and the deceased were found together alive and when the deceased was found dead is so small that possibility of any other person being with the deceased would be completely ruled out. It is important. ତେଣୁ ତା ଭିତରେ 3:30 ବେଳୁ ତା ପରଦିନ ଅପରାହ୍ନ 3:30 ବେଳୁ ତା ପରଦିନ 9:30ରେ ଆଉ ଗୋଟେ ଜାଗାରେ ଡେଡ୍ ବଡି ମିଳୁଛି, ତେଣୁ the possibility of other person coming in contact of the deceased cannot be totally ruled out. ଯଦି ସେ possibility ଆସିଲା ତାହେଲେ last sin କୁ ଧରାଯିବନି. କଣ ହେଲା, ଡିସିସନ ଆଣିଛନ୍ତି?
I have read the one. The burden lies on the petitioner. Recent decision 2023 SCC online.
এটা রামগোপাল কোউ ডিসিশনটা, এটা কোউ প্যারাগ্রাফটা?
ଇଏରେ ପ୍ଲାସିଟମରେ ମୁଁ ପକେଇବି।
ନାଇଁ ରାମଗୋପାଳଟା ଆପଣ ଦେଇଛନ୍ତି?
ୟେସ୍।
ହଁ କୋଉଟା?
Evidence Act section 106 fact proved to be within the special knowledge of the accused.
ନା ଏଠି କଣ ଓନ୍ଲି ଲାଷ୍ଟ ସିନ୍ ଥିଲା ନା ଆଉ ଅନ୍ୟାନ୍ୟ ଜିନିଷ ଥିଲା?
ଆଉ recovery of the weapon.
ରିକଭରିଟା ଅଛି। That's not here.
Accused throw the light upon such fact, effect, circumstance when accused does owe explanation under 106 principle summarized. 302 murder trial. Deceased murder by the petitioner accused herein using acts. Case based on circumstantial evidence. Fact the deceased was last seen together with the petitioner. Established.
Who jagare? That is another relevant issue.
Para 5 to 12 consider.
We come to paragraph 5.
Yes. It cannot be gain.
Paragraph 5 asandu. It cannot be gainsaid.
Gainsaid that when the entire case of the prosecution.
Just a minute. Again read it. It cannot be
gainsaid that when the entire case of the prosecution hinges on the circumstantial evidence, the entire chain of circumstance has to complete proof,
right,
which uneagerly would lead to the guilt of the accused and none else. So far, the evidence on record the present case is concerned, it emerged that it was not disputed that on 19/12/95 at about 5 p.m., the petitioner accused had taken the deceased Pratap Singh from his house. Thereafter, the deceased and the petitioner were also seen together at the shop of one cripple at village Arhela by the witness Vijay Singh. It was also not disputed that next day morning, the dead body of the deceased was found lying near the field of village Chacha Chiha. Hence, the death of the deceased Pratap Singh had taken place during the night hour of 19th and 20th, 1295, and that the petitioner was lastly seen with the deceased on the previous evening. Thus, it was the petitioner alone who knew as to what happened after the evening 19/12/95.
Yes.
Para 6. It may be noted that once the theory of last seen together was established by the prosecution, the accused was expected to offer some explanation as to when and under what circumstances he had parted the company of the deceased. It is true that the burden to prove the guilt of the accused is always on the prosecution. However, in view of Section 106 of Evidence Act, when any fact is within the knowledge of any person, the burden of proving the fact is upon him. Of course, Section 106 is certainly Evidence Act. Yes, not intend to relieve the prosecution of its duty to prove the guilt of the accused. Nonetheless, it is also equally settled legal position that if the accused does not throw any light upon the facts which are proved to be within his special knowledge in view of Section 106 of the Evidence Act, such failure on the part of the accused may be used against the accused as it may be provided an additional link in the chain of the circumstance required to be proved against him. In the case based on circumstantial evidence, furnishing or non-furnishing of the explanation by the accused would be very crucial fact. When the theory of last seen together as pronounced by the prosecution was proved against him.
You leave those two decisions. You come to paragraph number in so far as this case is concerned.
Yes.
Paragraph 9 person. কারণ সেটা দুইটা ডিসিশন সেটি কোট করি তারপর সে দুইটা paragraph 9 in view of the aforesaid legal position.
Legal position, it is discernible that though the last seen theory as propounded by the prosecution in a case based on circumstantial evidence may be weak kind of evidence by itself to base conviction solely on such theory. When the said theory is proved coupled with other circumstances,
it is important.
Yes, other circumstances such as time and when the deceased was last seen with the accused and the recovery of the corpus being in very close proximity of time, the accused does owe an explanation under Section 106 of Evidence Act with regard to the circumstance under which death might have taken place. If the accused offer no explanation of or furnish a wrong explanation, abscondent's motive is established and some other corroborative evidence in the form of recovery of weapon, etc., forming a chain of circumstances established, the conviction would be based on such evidence.
ତା ଦେହରେ ଏ କେସରେ ମୋଟିଭ ଏଷ୍ଟାବ୍ଲିଶ୍ଡ ହେଲା, ଅଦର କରୋବରେଟିଭ ଏଭିଡେନ୍ସ ଥିଲା, ତା ସହିତ ଯୋଉ ଲାଷ୍ଟ ସିନ୍ ହେଲା ତାର ଇମିଡିଏଟଲି କ୍ଲୋଜ ପ୍ରକ୍ସିମିଟିରେ ଡେଡ୍ ବଡିଟା ରିକଭରି ହେଇଛି.
Yes, sir.
Okay, then come to paragraph 10.
10. So far as the fact instances are concerned, it is duly proved that the death of the deceased was homicidal. It was not disputed the petitioner had taken the deceased with him on the previous day evening and thereafter he
ଆଦେହରେ
was
ସେ ଜିନିଷଟା ଡିସ୍ପ୍ୟୁଟ ମଧ୍ୟ କରୁନଥିଲା
ନା.
accused, which is disputed here. ହେଲା? Yes, next.
He was also seen the deceased by the witness Vijay Singh, and the very next day, early morning, the dead body of the deceased was found lying in the field of Chiha. At the time gap between the period when the deceased was last seen with the accused and the recovery of the corpus of the deceased being quite proximate, and the non-explanation of the petitioner with regard to the circumstance under which and when the petitioner had departed the company of the deceased was a very crucial circumstance proved against him. Having regard to the oral evidence of the witness, the enmity between the deceased and petitioner had also surfaced. The corroborative evidence with regard to recovery of the weapon X alleged to have been used in the commission of the crime from the petitioner also substantiate.
So ଦେଖନ୍ତୁ enmity ତା ମାନେ motive ଟା ରହିଲା,
motive.
Then ରହିଲା recovery ରହିଲା, last scene ଟା ଇଏ ଭିତରେ close proximity ରହିଲା, ଏଇ ସବୁ ରହିକିନି otherwise ସେମାନେ କହିଥିଲେ ଏଠି ତାର ଯୋଉଟା paragraph 9 ରେ it is reasonable that though the last scene theory as propounded by the prosecution in a case based on maybe weak kind of evidence by itself to base conviction solely on such theory, ସେଟା ମଧ୍ୟ same view, କିନ୍ତୁ ସେ କହୁଛନ୍ତି ଯୋଉଠି coupled with other circumstance ଆସିଗଲେ ତାହେଲେ ହବ. ଏଠି ଆପଣଙ୍କର other circumstance ନାହିଁ.
ନା.
ବାକି ତାପରେ ଆସିଲା କଣ ଏଇଟା ତାପରେ କିଏ ଦେଇଛନ୍ତି? Next, Dinesh Kumar. Mr.
No,
you have given?
no, Dinesh I have not given one.
ନା ଦିନେଶ ତୁମକୁ ମୁଁ ଖାଲି ଗୋଟେ ଦେଇଛି ରାମଗୋପାଳ.
ହଁ ଆଚ୍ଛା ଦିନେଶ କୁମାର ତାମାନେ ଆପଣ ଦେଇଛନ୍ତି ଷ୍ଟେଟ୍ ଅଫ ହରିୟାଣା. ଏଥିରେ କଣ ପାଇଁ ଦେଇଛନ୍ତି? ଏଟା କୋଉ ଲାଷ୍ଟ ସିନ୍ ଅଛି ଏଥିରେ? 13-15. Come to 13-15, let us see.
ଦିନେଶ କୁମାର ନାହିଁ ତ?
There are 4 judgments.
Lordship, my lord, that live loss.
Oh, live loss.
Truth and lordship.
Live loss.
13 and 15.
You come to paragraph 12. Have you got that?
Lordship, my lord. 12, my lord.
এটা হচ্ছে ଆପଣଙ୍କର ଦିନେଶ କୁମାର versus state of Haryana, right? 2023 live law SC 395.
395.
And paragraph 12 is relevant.
The evidence of last scene become an extremely important piece of evidence, and that's some that
case of circumstances.
The evidence of last scene becomes an extremely important piece of evidence in case of circumstantial evidence, particularly
when there is a close proximity in the case between the accused was last seen with the deceased and the discovery of the
close proximity very important. Close proximity between the accused last seen with the deceased and discovery of the dead body
of the deceased,
or in this case, the time of the death of the deceased. This does mean that in cases where there is long gap between the last scene and the death of the deceased, the last scene evidence loses its value. It would not be, but then a very burden is placed, heavy burden is placed on the prosecution to prove that during this period of last scene and discovery of the body of the deceased or the time of death, no other person, again that no other person but the accused could have had an access with the deceased. The circumstance of এটা जो अंजन कुमार ये रिलाय करछन्ती और cannot form the हैला जोटा हमें प्रथम प्लेस करथु अंजन कुमार वर्सेस स्टेट ऑफ आसाम. Then other decision देइछन्ती. Then you come to 2005 paragraph number 12.
That is that Kanhalal decision, that
13, paragraph 13. Now you come to 9. Say 13 jiya purva sub paragraph ta dekhon. To the burden of proof. Say decision. Say page ro paragraph 13 na just purva. Mane 12 ro jo top ro asan. The burden of proof is always on with the prosecution. Paile. 13 number paragraph ko asile.
That's missing in my page, bro.
Paragraph 9.
Miss
The burden of proof is always on the prosecution. It is the prosecution which has to prove its case beyond reasonable doubt. 106 of the Evidence Act does not alter this position. It only leaves burden of this for disclosure of a fact on the establishment of certain circumstances. We have no reason to doubt the testimony of PW10, the sole testimony of Lasin. In his statement under section 313 of CRPC, when the apparent was questioned about being in the company of the deceased on 8/5/2000, along with the accused, co-accused Mangeram, no explanation was given by the apparent about his whereabouts. It is for this reason that it has been held that the accused has not been able to discharge his burden under section 106 of the Evidence Act, and therefore it has to be read as an additional link in the chain of evidence against the apparent. To our mind, howsoever section 106 would not even come into play here under the facts and circumstances of the present case. After 13 case, what has to be kept in mind
is that section 106 of the Act only comes into play
when other facts
have been established by the prosecution. In this case, when the evidence of the last scene itself is on a weak footing, considering the long gap of time between the last scene by PW10 and the time of death of the deceased, section 106 of the Act would not be applicable under the peculiar fact and circumstances of the case.
Now you come to the other paragraph, that is
15.
Paragraph 15.
In our considered view, in the present case, the prosecution has not been able to prove its case beyond reasonable doubt. The evidence of last scene only leads up to the point and no further. It falls
leads up to a point.
And no further. It falls to link it further to make a complete chain.
It fails to link
it further
to make a complete chain.
All we have here, the evidence of last scene, which is we have seen loses much on its weight under the circumstances of the case. Due to the long duration of time between last scene and the possible time of death, what we can call as a discovery here under section 27 of the Act, the discovery of Parna and watch of the deceased, the evidence itself is not sufficient to fix guilty on the appellant.
Dinesh Kumar ta magediyo SCC report hochi Dinesh Kumar versus State of Haryana. Hala? Supreme Court judgment. delivered on May 4, 2023. Justice होउछंती सुधांशु दुलिया and संजय कुमार हैला. Then next आपण आ गोटे प्रेस करछंती
2005-12 Supreme
right,
Court,
right, हाँ
438,
एटार को
Para 5
paragraph
ma'am.
paragraph 5 अच्छा.
5. Apart from the
Wait,
extra,
wait, wait, wait.
Lordship.
Paragraph 5, yes.
Apart from the extrajudicial confession, which we shall advert to a detailed letter, the main incriminating fact relied upon is that the deceased was last seen by PW14 in the company of the appellant and the other accused, and that he was given a lift in the vehicle belonging to the appellant. In order to establish that the vehicle belonged to or was in de facto possession of the appellant, some evidences has been let in. The last in evidence is sought to be established by the testimony of PW14. At the outset, you must observe that there is a serious doubt cast on the version of PW14 about the deceased going in the vehicle of the appellant. The destination of the deceased was uh, Pihua, whereas the vehicle had come from Pihua and was proceeding towards Debigarh, which is in a different direction. Prima facie, there is no apparent reason why the deceased would have chosen to go in the vehicle which was proceeding to some other destination. The High Court resorted to a guess that the deceased would have been
Without probing further into the correctness of last seen version emanating from so-and-so evidence, even assuming that the deceased did accompany the accused in their vehicle, this circumstance by itself does not lead to the irresistible conclusion that the appellant and his companion had killed him and thrown the dead body in the culvert. It cannot be presumed that the appellant and his companion were responsible for the murder, though grave suspicion arises against the accused. There is considerable time gap between the deceased boarding the vehicle of the appellant and the time when PW11 found the dead body. In the absence of any other links in the chain of thought, so it is not possible to convict the appellant solely on the basis of last seen evidence, even if the version of PW14 in this regard is believed.
The evidence of PW9 is
leave it that now the next one, the last one is Kanhaiya Lal टा गोटे कोर्ट करते ସେମାନେ स्टेट ऑफ राजस्थान वो जो आमे प्रथम जो डिसीजन टा देखथिलु
2017-14 SCC report.
कन्हैया लाल भी कोर्ट हेतला कन्हैया लाल राइट पैराग्राफ 12 कोर्ट हेतला ठीक अछि. Baki, now you come to the doctor's evidence that PM doctor, he is PW
8.
Okay. That we find that PM was conducted on 4/10/1999 and time was 1:30 PM. That is as per the PM report. Bartaman, see time since death kete kouch
12 to 24 hours.
24 hours. That comes within the last scene.
ନାଇଁ ତାମାନେ ସେଟା ହେଇଥିବ ଘଟଣାଟା ହେଇଥିବ ତାମାନେ ସିଏ ଯାହା କହୁଛି ଡକ୍ଟର 3/10 ଅନେଶତର ଦିନ 1:30 ରୁ ରାତି 1:30 ଭିତରେ ହେଇଥିବ ହେଲା. ଡାକିଦବା ଜଜମେଣ୍ଟ ନାହିଁ ଆଉ ଲେଖନ୍ତୁ ଆଉ ଗୋଟେ ଜଣକୁ ଡାକ ଜଜମେଣ୍ଟ ପାଇଁ ହେଲା। Please take your seat. The spelling which is there, Mr. Tripathi, that is correct. Sushanta,
S-U-S-A, my lord.
not S-A.
H-M, S-U-S-A-N-T.
S-U-S-A-N-T-A.
S-A-N-T. No, sir.
And Sushant Kumar Rahibo.
Kumar.
You are engaged as amicus curiae, no?
No, sir, my lord.
Yes, को order रे देखिलो. Right. That is 5 to 24. ଦେଖିଦେଲ ସକାଳ ଗୋଟେ JCRL number JCRL number 148 of 2005. There are 3 appellants in this JCRL, namely Mangara Munda, Gobara Munda, and Sunia Munda alias Kate, K-A-T-E. तेरा कहीं से जो डेट थी बोली रिपोर्टर स्टेट गवर्नमेंट जोड़ के लिखा हूँ. The Learning Council for the state has produced the written instruction received from IIC Koida Police Station, Rourkela, dated 16/3/2023, wherein it is mentioned that the appellants Mangra Munda and Gobra Munda are living with their families and maintaining their livelihood by doing daily labor, whereas the appellant Sunia Munda alias Kate is dead since 10 to 12 years. In view of Section 394 bracket 2 of CRPC, since no near relative of the appellant Sunia Munda alias Kete has applied before this court for leave to continue the appeal. This JCRLA in respect of the said appellant Sunia Munda alias Kate stands abated. Therefore, now this JCRLA is confined to appellants Mangra Munda and Gobara Munda. Both these appellants, along with Sunia Munda alias Kate, face trial in the court of London ad hoc additional session judge Bonai in ST case number 29/72 of 2000-2004 for commission of offences under section 302/34 of the Indian Penal Code and 201/34 of the Indian Penal Code on the accusation that on 3/10/1999 at about 3 p.m. near Chandipos Road side, they committed murder of Keshav Patra, bracketary hereafter the deceased, who happened to be Gramarakhi, by means of a stone in furtherance of their common intention. লেখা আছে near Chandipos Road side বলে, okay. And knowing or having reason to believe that the offense has been committed, they caused certain evidence of the said offense to disappear by concealing the dead body of the deceased inside a ditch situated inside the jungle of Chandipos with the intention of screening themselves from legal punishment in furtherance of their common intention. The Lennon Trial Court, by judgment and order dated 26/7/2005, found the appellant guilty, appellants kar deba, guilty of both the charges and sentenced each of them to undergo imprisonment for life and to pay a fine of rupees 1,000 in default to undergo simple imprisonment for 1 month each. However, no separate sentence was awarded for the offense under section 201 of the Indian Penal Code. PW3, next para, Karunakar Patra lodged the first information report on 4/10/1999 before the officer in charge of Koira Police Station wherein it is stated that while on that day in the morning hours, he was proceeding towards Matadin, near Chandi Post, by the side of road. The dead body of the deceased was found, and it was suspected that somebody has killed him by attacking him on his head with a stone. On the basis of such first information report, PW13 Prakash Chandra Pal, the OIC of Koira Police Station, registered Koira PS case number 31 dated 4/10/1999 under section 302 of the Indian Penal Code against unknown persons, and took up investigation of the case. He examined the informant, recorded his statement, and made requisition to DFSL Rourkela for the scientific team and dog squad. He visited the spot and prepared the spot map marked as Exhibit 13. He held inquest over the dead body of the deceased in presence of witnesses and prepared the inquest report marked as Exhibit 11. The dead body was sent for post-mortem examination. A letter issued to the deceased by PW13 with a direction to produce appellant Kate Munda was seized. So also one stone weighing about 10 kg stained with blood as per seizure list Exhibit 7. PW13 examined some more witnesses, arrested all the accused persons, seized their wearing apparels under seizure list Exhibit 3, 4, and 5. The wearing apparels of the deceased were also seized as per seizure list Exhibit 2 on being produced by the constable after post-mortem examination. On 5/10/1999, requisition was made to Medical Officer Quera PSC for collection of blood sample and nail clippings of the accused persons. PW13 made a query to the Medical Officer Quera CSC for examination of the stone and opinion regarding possibility of the injury sustained by the deceased with such stone, and received the opinion and also the post-mortem examination report of the deceased. On the prayer of the IO bracket PW13 before the SDGM Panay, the seized articles were sent for chemical examination to RFSL Ointapalli Sambalpur, and chemical examination report exhibit 16 and serological report exhibit 17 were received by PW13, and on completion of investigation on 21/12/1999, he submitted charge sheet against the appellants under section 302(201)/34 of the Indian Penal Code. After the case was committed to the Court of Session following due procedure, the London Trial Court framed charges as aforesaid, and since the appellants pleaded not guilty and claimed to be tried, the sessions trial procedure was resorted to establish their guilt. In order to prove its case, the prosecution examined 12 witnesses. Give the details. The prosecution also exhibited 17 documents, and it also proved 3 material objects. Next para. The defense plea of the appellants was one of denial. The London Trial Court, after assessing the oral as well as documentary evidence on record, came to hold, basing on the evidence of the medical officer, the post-mortem report, the inquest report, that the deceased suffered a homicidal death. The London Trial Court accepted the version of PWs 4, 5, 9, 10, and 11, who have stated about the last scene of the appellants in the company of the deceased. And further held that some quarrel took place between the appellants on one hand and the deceased on the other. The London Trial Court further held that since the occurrence took place in a secluded place and the dead body was lying in a ditch, in the circumstance, it is very difficult to find out the exact time when the occurrence took place. However, held that the death must have occurred after 3:30 p.m. and within 2 to 4 hours from the leaving of the house of the deceased for the last time. The Lenin trial court further held that since the deceased was taking the appellant Kate Munda along with the other appellants to the police station, there might have been some apprehension in their mind for which they might have decided to eliminate the deceased. It is further held that the prosecution case cannot be viewed with suspicion even if the evidence is lacking as regards to the motive on the part of the appellants to kill the deceased. The Lenin trial court also took into account that the wearing apparels of the deceased contained human blood of group B and the same blood group was detected on the sky colored full pant of the appellant Kate alias Sunia Munda. And no explanation has been offered by the said appellant as to how the blood group of the deceased got strained with his pant, but simply he has taken denial plea during his examination under section 313 of CRPC, which is an additional circumstance against the appellant Kate alias Sunil Munda, Sunia Munda. It was further held that since the appellants Mangra Munda and Gobara Munda were also in the company of the deceased along with the appellant Sunia Munda alias Kate, they are sharing common intention in committing the murder cannot be ruled out. The Lenin trial court summed up the evidence on record and observed that the following circumstances are available against the accused persons in the case. Paragraph 11 में जो 7टा ये तो कोट कर दो. And ultimately concluded that the appellants committed the ghastly murder of the deceased, who was the Gramaraki, while discharging his duty as such by taking the appellants to the police station on being instructed by his superior officer, that is, officer in charge of Koira police station, and found the appellant guilty under section 302 by 201 by 34 of the Indian Penal Code. Mr. Sushant Kumar Tripathi, Sushant Kumar Tripathi was engaged as the amicus curiae by this court as per order dated so and so. Argued that even though it is not disputed that the deceased suffered homicidal death in view of the evidence of the doctor bracket PW8 and other materials available on record, but that there was a quarrel between the appellants on one side and the deceased on the other side, which was noticed by the witnesses. So also that the deceased was last seen in the company of the appellants is a doubtful feature. It is further argued that last seen circumstance itself is not sufficient to convict the appellants, and there is no motive behind the commission of crime. Rather, the evidence of the wife of the deceased, who was examined as PW11, indicates that there was cordial relationship between the appellants and the deceased. The Land Council further argued that the documentary evidence which has been proved by the prosecution in this case, that is Exhibit 7/2, which is an intimation by PW13 to the deceased, indicates that it was only the appellant Sushant Munda alias Kate who was called to the Sunia Munda alias Kate, who was called to the police station for compromise of the dispute, and therefore it is not understood as to how, why, and how the appellant Gobra Munda would accompany the deceased to the police station. The Land Council submitted that even though from the sky color full pant of the appellant, Sunia Munda alias Kate, human blood group B was detected, which blood group was also detected in the wearing apparels of the deceased as per the C report. Marked as Exhibit 17. But since nothing has been, but since from the wearing apparels of the two appellants, that is Mangra Munda and Gobra Munda, no human blood was noticed, comma, the C report cannot be utilized against them. It is further argued that last scene portion is submission, that since the time gap between the last scene and the recovery of the dead body was long, cannot be the sole ground to convict the appellants. Reliance has been placed the decision of the Honorable Supreme Court in case of Anjan Kumar Sharma versus State of Assam, reported in 2017 14 Supreme Court cases 359, Dinesh Kumar versus State of Haryana, reported in 2023 SCC Online SC 564. ଆପଣ କୋଉ ଡିସିସନଟା ଦେଇଥିଲେ ମିଷ୍ଟର ତ୍ରିପାଠୀ?
Ram Gopal.
ଆଚ୍ଛା,
Ram Gopal.
okay. तापरे होची जसवंत गिर versus State of Punjab, reported in 2005, volume 12, SCC 438. Kanhalal Bakra में अच्छी तरह रिपोर्ट है
year wise बदले 5 से 12 तापर
serial. Mr. Tripathi led an additional standing counsel, on the other hand, supported the impugned judgment and argued that PW4 and PW5 have seen the quarrel while the deceased was in the company of the appellants in the afternoon, and thereafter the deceased was not seen alive, and his dead body was found on the next day at about 9 o'clock in the morning. And the appellants have not discharged their burden under Section 106 of the Evidence Act as to when they parted with the deceased after they were last seen. And they have simply taken a plea of denial. The Land Council further argued that though no clinching evidence relating to the motive behind the commission of the crime has been established, but the possibility of the appellants committing the crime as they were taken to the police station by the deceased cannot be ruled out. The Land Council further argued that in view of the C report finding that the same blood group of the deceased was found on the pant of the appellant Sunia Munda alias Kate, these circumstances form the complete chain. Therefore, the London trial court is quite justified in holding the appellants guilty under Section 302(y)34 of Indian Penal. Next para. There is no dispute that there is no direct evidence in this case, and the case is based on circumstantial evidence. In view of the settled position of law relating to the appreciation of evidence in a case which is based on circumstantial evidence, as held in case of Sarath Brichyan Sarda versus State of Maharashtra, 1984, for Supreme Court cases 116, wherein it is laid down as follows, quote from 360 bracket portion it is to be seen how far the circumstances have been established by the prosecution and whether those circumstances form a complete chain unerringly pointing towards the guilt of the appellants or not. Heading कर दो motive behind the commission of crime. In a case of circumstantial evidence, absence of motive is a very significant factor. In the case in hand, the evidence of PW11 Okila Patra, the widow of the deceased, indicates that on the date of occurrence, the appellant Mangra Munda came to their house in the morning with a notice from Koira police station and delivered the same to her deceased husband. The deceased told the appellant Mangra go to village Udadihi to call the other two appellants as they were required by the police as per the notice, since a quarrel had taken place between the appellant Mongra Munda on one side and the other two appellants on the other side. She further stated that after taking tea, the deceased left for the village Podadihi to call the appellants, and at about 3 p.m., the deceased came back along with the appellants and instructed her to serve them food. She further stated that on being so instructed, she served country, rice, beer, and one plate of chicken to the appellants. And after taking their meal, the appellants, being accompanied by the deceased, went towards Koira police station. In the cross-examination, PW 11 has stated that the appellant Kate and Gogora used to call the deceased as Mamu, bracketary uncle, and they were having good terms with the deceased. The son of the deceased and PW 11 being examined as PW 10 has stated that on 2/10/1999, the deceased received a notice from Koira police station to take the appellants, namely Kate and Gobra, to the police station. And on 3/10/1999, the deceased went to village Udadihi and came back with the appellants at about 1 p.m. And thereafter, the deceased took his meal and the appellants took handia being served by PW 11, and then they left for Koira police station. From the evidence of PW 10 and PW 11, it appears that there was cordial relationship between the appellants and the deceased. At this stage, the notice which was issued by PW 13 to the deceased, which has been marked as Exhibit 7/2, needs to be considered. The IO bracketary PW 13 has stated that the said notice was issued to the deceased by him with a direction to produce the appellant Kate Munda before him. And Exhibit 7/2 also indicates that it was only meant for production of Sunia Munda alias Kate for the purpose of compromise. There is no mention in the notice that the appellant Gobara Munda was also required by PW13. The London Council for the State argued that since Gobara Munda and Sunia Munda alias Kete are two brothers, the possibility of both of them accompanying appellant Mangra Munda, who had complained against them, so also the deceased, cannot be ruled out. The last scene here eta likhibe na. Coming to the last scene, we find that there are 5 witnesses who depose about the same, and they are PW4, PW5, PW9, PW10, and PW11. PW4 Soti Patro has stated that he didn't know the appellants. She could not identify the appellants in the dock. She only stated that while she, along with other co-laborers, were engaged in weeding operation in her land, she found the deceased along with 3 persons were proceeding towards Koeda, and she heard some quarrel between them. She stated that the distance between her and those persons were 70 to 80 cubits. However, in the cross-examination, she has stated that the voice from the road was not audible from the land where they were engaged in weeding work. And village Chandipos was at a distance of 1 kilometer away from their village. And he had not disclosed before any of his family members regarding the quarrel that took place between the deceased and the 3 persons. And he was examined by the IO after 1 month of the occurrence. Therefore, from the evidence of PW4, it cannot be said that the appellants were in the company of the deceased, and that he could able to hear the quarrel, she could able to hear the quarrel between them. PW4 has not stated that PW5 was also working with her. Our PW5 stated that at about 12 noon on the date of occurrence, while she was carrying out weeding operation with PW4, she noticed the deceased with 3 persons moving towards Koida police station, and those 3 persons were quarreling with the deceased, and PW5 identified the appellants in the dock to be those 3 persons. She further stated that the appellants were working as laborers with her in the mines. And further stated that after finishing the wedding work, she went to her house at about 4 p.m. 12 noon लिखला तो ऊपर है ना? All right. In the cross-examination, however, she has stated that she had got no prior acquaintance with the appellants. This statement runs contrary to her evidence in the chief examination that the appellants were working as laborers with her in the mines. She further stated that she used to go to her work in the morning and return home in the afternoon. From the evidence of the widow of the deceased, who was examined as PW11, it appears that at about 3 o'clock in the afternoon, the deceased came with the appellants, and she served them food, and thereafter the appellants, being accompanied by the deceased, went towards Koira police station. In view of such timing as stated by PW11 to be leaving the house, it is very difficult to accept the evidence of PW5 that at about noon she could see the appellants in the company of the deceased. Moreover, she has stated that in the cross-examination that even if somebody shout loudly on the road, it would not be audible to the place where they were working. Therefore, we are of the view that the evidence of PW4 and PW5 are no way helpful to the prosecution to establish the last sin of the deceased in the company of the appellants. Before going to the evidence of the other 3 witnesses to the last sin, it is relevant to discuss the evidence of the doctor. The doctor, bracketed PW8, has noticed the following injuries. Quote kar dega. These are the internal injury, and cause of death is this. And he has stated that the time since death was 12 to 24 hours. The doctor conducted the postmortem examination on 4/10/1999 at 1:30 p.m. And in view of the evidence of PW8, the death must have taken place in between 1:30 p.m. on 3/10/1999 TO2 1:30 a.m. on 3/4/10/99. The three witnesses who remained for the prosecution and deposed about the last scene have stated that the deceased was seen in the company of the appellants in the afternoon at about 3 to 3:30 p.m. The dead body was found by PW3, the informant in the case, towards Matadin at near Chandi Post on 4/10/1999 at about 9 a.m. by the side of the road. Therefore, the place where the appellants and the deceased were last seen and the place where the dead body of the deceased was found were not only different, but there was sufficient time gap between the two and even between the time they were last seen and the death, maximum death period, which has been stated by the doctor. Therefore, the possibility of someone else company coming in the contact with the deceased cannot be completely ruled out. In the case of Anjan Kumar Sharma, the Honorable Supreme Court taking into account the ratio laid down in the case of Kanhaiyalal versus State of Rajasthan, reported in 2014, bracket with a revo, bracket bare 4, Supreme Court cases 715, Arjun Marik versus State of Bihar, 1994 SCC Criminal 1551, Bharat versus State of MP, 2003 SCC Criminal 738, so also State of Goa versus Sanjay Thakran, 2007 3 SCC 755, held as follows. लिखिए paragraph 19 है ना, पेज होची 369, paragraph 20 page 370, paragraph 321 page 370 and paragraph 23 है ना, quote कर दो. In case of Dinesh Kumar, The Honorable Supreme Court has held as follows: paragraph 25. '26, 27, 28, 29. Hello? SCC online এটা যদি লাইভ লোড আছে তুমি এথ্রু করিও হলো নেক্সট in case of Jaswant Gir Supra, the Honorable Supreme Court held as follows: quote paragraph number 5. In view of the settled position of law, since we find no other links against the appellants, to connect them with the crime, the circumstance of last sin itself cannot be a factor to convict the appellants for commission of murder of the deceased. Even though no explanation has been offered by the appellants in their accused statement. In view of the time gap between the point of time when they were seen together and the deceased was found alive, and when the deceased was found dead on the next day, the possibility of other person being with the deceased cannot be completely ruled out. The decision relied upon by the learned counsel for the state that is Ram Gopal Bracketer Supra, the Honorable Supreme Court held as follows. Quote from paragraph number 5, 6, 9, 10, the factual scenario of the case of Ram Gopal is totally different from the case in hand, in as much as there are other circumstances against the appellant in that case, like enmity between the deceased and the appellant, recovery of the weapon of offense used in the commission of the crime from the appellant, apart from the last sin. In the case in hand, even though the prosecution has proved that deceased has met with homicidal death, but since no motive behind the commission of the crime against the appellants has been proved, rather it appears that there was cordial relationship between the appellants and the deceased, and the last sin evidence adduced by PW 4 and 5 is not acceptable in view of the reasons as discussed above, and the evidence of last sin adduced by PW 9, 10 and 11 are not sufficient in itself to come to the conclusion that it is the appellants who are the authors of the crime, and the findings in the C report is no way relevant for the two appellants, Mangara Munda and Gobra Munda, are concerned. We are of the view that it cannot be said that the circumstance which have been established by the prosecution completes the chain, and it unerringly points towards the guilt of the appellants Mangara Munda and Gobra Munda. Therefore, it's a fit case where the benefit of doubt is to be extended in favor of the appellants. Accordingly, the impugned judgment and order of conviction of the appellants under section 302-201/34 of the Indian Penal Code is hereby set aside. The appellants are acquitted of the charges. Both the appellants, Mangara Munda and Gobra Munda, are on bail. Their bail bonds, they are discharged from the liability of the bail bonds. Surety bonds stands cancelled. Put a note of appreciation on Mr. Tripathi, both the Tripathi, and 7,500 is to be given to the learned amicus curiae.
Pardon to make a mention, my lord. Lord, matter is of exceptionally urgent matter, my lord. I am challenging the notice of auction which is to be held on Monday, my lord. The matter. Grateful.
And this is a fresh matter of the item.
My lord, this is the mention memo of the accused in custody since 2015. This is the
Yes, yeah.
Supplementary list item number 1.
If I may please your lordship, my lord,
But offences under 30234 and subsequent to the filing of charge sheet, 3 SC/ST has also been implemented as offences. My lord, notice has to be issued. My lord, may I pray that the
Yes, Mr. Das, extra copy, notice, CD, CA, confirmation letter. Yes.
gratefully, Lord,
From 1 week after. Yes.
grateful, my lord.
Item number 2.
Item 2, my lord, the appellants are approached earlier, my lord, but inadvertently the mistake, my lord, the certificate could not reflect the same. The appellants have earlier approached this honorable court, but my lord, inadvertent mistake, my lord, the same shall not be reflected in the certificate, my lord. I am filing the memo, my lord. Earlier approach court.
What is the number of that?
My lord, CRLA 110/2023. But the same shall not be reflected in the certificate, my lord. I am filing the memo. नहीं मैं appellant.
Otherwise, it is a fresh matter.
My lord.
So SC/ST.
My lord, 3 SC/ST.
All right, same or extra copy.
I am serving extra copy in course of the day.
Extra copy serve in court कर देवे. Notice गला CDCA. है बाकी confirmation letter. Date same as item number 1. Yes.
Item number 3.
SC/ST matter. Press matter. Okay, same order. Extra copy. Notice CDCA. Confirmation letter. Yes.
Item number 4.
Extension allowed. Extension allowed. Next.
Item number 4.
Come item number 6. You are not following what is. Yes.
Item number 6.
Lordships. In item number 6, in the
Yes. Also,
Lordship, item 12, Lordship. Power may be withdrawn, Lordship. Previous conducting council, Pratik Naik,
Pratik Naik, okay,
already prisoner person already.
right, that is Suryakant Das Mahapatra ko नाम आसची.
Yes, Lordship.
Pratik A. Bhuya is the associate of Pratik Naik.
Pratik Naik and A. Bhuya.
A. Bhuya, all right. Since अच्छा पेरी ऑफ द प्रिजनर्स पिटिशन अच्छा अब ये फाइल कर दीजिए वी नामा मिस्टर सूर्यकांत दास महापात्र फाइल कर वी नामा हाँ खाली प्रिजनर्स पिटिशन दास जी
As per the noting is only for a prisoner person.
हाँ ठीक है प्रिजनर्स पिटिशन ने तो ना ठीक से लिखा है जी सूर्यकांत दास महापात्र हाँ ये जो मोबाइल नंबर को क्या देखिए काउंसिल का मोबाइल नंबर नहीं all right since prisoner's petition has been received at flag C for engagement of advocate Mr. Surjakanta Das Mahapatra in place of advocate Pratik Naik, the London Council. You are Mr. What is your name?
Vishwaranjan Swai.
You are mentioning the matter on behalf of.
On behalf of Pratik Naik.
A mention is made on behalf of Mr. Pratik Naik, advocate, that his name, so also the name of Mr. A. Bhuya, may not be reflected in the cause list henceforth. Since Mr. Suryakant Das Mahapatra has not filed VNAMA, let him do so within a period of 2 weeks from today. The names of Mr. Pratik Naik and A. Bhuya shall not be reflected in the cause list henceforth. Yes.
Item 13.
May I please? Offense on 20B2C and a original person custody for 10 years. Out of 10 years, she was a custody near about 7 years. And last occasion, I filed the surety affidavit, and that is.
He's an outsider.
Yes, my lord.
Where is the West Bengal?
West Bengal, my lord.
So, what instruction you have received?
Yeah, address verification. Address is correct.
Address is correct.
Yes.
Have you given
and the surety verification received lately, my lord. We have not sent it.
Acha. So you get it that
Yes.
The London Council for the state submitted that the London Council for the appellant supplied the details and documents of two local sureties late in spite of the order dated 29/11/2023 for which he has not obtained instruction about the genuineness of the bailers and authenticity of the documents, and he may be given some more time in that respect. Put up this matter in the week commencing from 26th February 2024.
Obligation.
Item 14.
That's on the last occasion, your lordship may kindly have a glance to order dated 12
Item 22.
22, Mr. Devasis Panda. What is the CRLA for?
Condonation of delay, my lord.
What is the delay? 239. Okay, Mr.
Yeah, he is another Devasis Panda.
Huh?
Yeah, how is it?
No,
After enrollment number 2021.
No, see, Mehta Agriga Ashandi na to. Se Devasis Panda no.
That's in item 22.
Yes.
On the last occasion, Your Lordship, we had stated that the appellant has died. We had communicated to the family. They had come and had a talk with us. I need some more time. That is what I'm praying. If they are willing to pursue.
Because the period is only 1 month.
Yes, my lord.
Once that process, then you are to file an application for
for
condonation of delay to continue the appeal.
They have not supplied us the wakalatnama also. So that is why I had spoken to them yesterday itself after getting the letter.
So interim application is to be filed along with the deal and that death certificate also.
Lordship may simply give me 2 weeks time if at all they.
All right. The learned counsel for the appellant submits that he is yet to receive instruction as to whether any near relative of the appellant who is dead is interested to continue this appeal or not, and the matter may be taken up 2 weeks after. Put up this matter in the week commencing from 4th March 2024.
I'm grateful, my lords.
Item 23.
In 23, my lord, state had filed objection for 1661 delay. This delay.
What is this criminal appeal for?
Milord, in filing I am also wrong, Milord. Because, Milord, what I challenged here, Milord, that is the order of Assistant Session Judge Baligoda. After that, an appeal is also prepared by the petitioner. That I have not challenged, Milord. That is my mistake, Milord.
Appeal was preferred where?
Additional Session Judge, Milord.
Then here, how can
Yes,
the
Milord.
appeal be
Yes,
maintainable?
it is not maintainable also, Milord.
Look, the learned counsel for the appellant submits that against the impugned judgment and order of conviction passed by the learned Assistant Session Judge Baliguda, criminal appeal was preferred in the Court of Session, and therefore this appeal is not maintainable. In view of such submission, the CRLA is disposed of. Yes, next.
Liberty, maybe.
Liberty of one. Seଠି criminal appeal ଯଦି allow ହେଇଯିବ ଆଉ liberty କ'ଣ ଦରକାର?
Obliged.
Item 24. Item 25.
Yes, Mr. Rothong.
My lord, it's a case, but
What is the delay?
the delay is
456.
my lord.
Mr. Have you filed your objection?
No objection has been filed.
The opportunity has been given to file you.
And my lord,
Has
delayed
been
due
served
to
so and so, non-appears for this so and so.
copy again thrice solved. Copy I have received. Partly COVID and partly CRLMC wrongly filed.
No, that's all right. But if
Right.
so, what do you say, Mr.
Hello.
The ground, you have got the IN copy. The IA, the delay has been shown to be 675 days.
My lord.
So
I'll some time may be granted, but I'll file the.
he's telling that he has already given you twice or thrice the copy of the.
We have received copy and ମାସ 23/12 ପାଇଁ ଏଇଠି ଆପଣ ରେକର୍ଡ ଯୋଉଟା ଅଛି ଆଉ ଗୋଟେ ପୂର୍ବରୁ ପା ଦେଇଛି
So whether that copy of the IA is available with you,
yes
then
available.
So whether you file or not, if you say no, I'll mention that.
No, I'm saying that after next week I'll file.
IA number 2970 of 2023. This is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 675 days in filing this CRLA. Mr. Patra, Learning Counsel, Special Counsel appearing for the State of Odisha in OPID Act matter, submits that he intends to file objection to the delay condonation application, and the matter may be taken up a week after. Put up this matter in the week commencing from 26th February 2024. Objection, if any, to the delay condonation application be filed in the meantime, giving copy to the Learning Counsel for the appellant. Yes.
Item 26. regard to defect number 3, which has been shown in this from filing a memo, my lords. The assessment has been
Defect number 3 होची 6 टंका पेमेंट ହେଇନି for the all right land council for the appellant has filed a memo तार दिए मरा ହେଇଛି court fee paying the court fee which is shown as a defect as by the stamp reporter. Accordingly, defect number 3 is removed. Yes.
My lords, here I have challenged an order of the learned additional sessions judge Bhubaneswar. That is at annexure. Annexure 7, my lords, missing.
31/7/2023.
Page, yes.
Yes.
That, by that order, he has rejected my petition, my lords. It reads like this. Page 98, my lords.
Yes.
98. Latter order. Order arises out of a petition under 340 CRPC filed by learned counsel for accused for conducting preliminary inquiry for giving of false evidence by PWs 2, 8, 9 and 31. Learned counsel for petitioner has submitted that during course of evidence witness Subhankar PW2, Shantanu PW8, Dharanidhar PW9 and Harishankar PW31 have deposed before the court as eyewitness to the occurrence. Further submitted that the said witnesses were inside the jail premises till 8:25 p.m. on the date of occurrence, whereas incident took place outside the jail premises at 6 p.m. Therefore, they have deposed false evidence before this court at the time of the examination and prayed for conducting an inquiry against them for giving false evidence. On the other hand, learned additional PP filed objection and submitted that after closure of evidence from both sides, now case is pending argument. And at this stage, the petition is filed with intention to linger the trial. On perusal of the case record, it reveals that it is a case on such and such, read with such and such. 36 witnesses have been examined from the side of the prosecution. Now case is pending for argument. Object of section 40 CRPC is to ascertain as to whether any offence affecting administration of justice has been committed in relation to a proceeding or given
in 340 inadvertently.
340. Though the witnesses have deposed as eyewitness, whether they were inside the premises or have seen the occurrence can be ascertained after appreciating the entire evidence at the time of final decision of the case. Therefore, neither petitioner has a prima facie case, nor any offence has been committed affecting administration of justice by their evidence for conducting an inquiry for giving false evidence at this stage.
So, what? Yes, Mr. Panda, what happened in this? Because it was posted to argument. In the meantime,
it is still pending, my lords. Arguments have not yet been concluded.
Why? Because 21/8/23 is the date of argument.
I understand.
Have you got that certified copy of the order sheet?
No, I don't have copies. I'll get copies. Your lordship may call it next.
One thing just I want to know about the how whether these witnesses admitted that they were inside the jail premises till cross-examination ବାହାରିଛି ଆଉ ଏଇ ଯୋଉ ବାହାରେ ହେଇଛି 6:26 ପର୍ଯ୍ୟନ୍ତ ତା evidence copy ଗୁଡାକ ଦେଇଛନ୍ତି?
ହଁ ଦେଇଛି, annexure କରୁଛି.
Okay, so whether you will produce or I will take instruction about the status of the case.
It's appropriately if your lordship asks the court, because Bhubaneswar now it's
Mr. Just verify those statements. Mr. Panda says that those witnesses have stated that the occurrence took place outside the jail premises at 6 p.m. So Sandhya 6ଟା ବେଳେ ହେଲା କିନ୍ତୁ ସେମାନେ jail premises ରେ ଥିଲେ 8:25 ଯାଏଁ ତ କଣ ହେଇଛି ଦେଖନ୍ତୁ ସେଟା ଏଭିଡେନ୍ସ ଟା ଦେଖନ୍ତୁ. Okay, this criminal appeal has been filed under section 341 of CRPC, challenging the order dated 31/7/2023 passed by the Learned Additional Session Judge Bhubaneswar in criminal trial case number 50/21/113 of 2013/2010. In rejecting the petition filed by the appellants for conducting a preliminary inquiry against PWs 2, 8, 9, and 31, namely Subhankar Mishra, Shantanu Kumar Hotta, Dharanidhar Sahu, and Harishankar Purohit, respectively, for giving false evidence during trial. From the impugned order, it appears that the case was posted to 21/8/2023 for argument. When a query is made to the Learned Counsel for the appellant about the status of the trial, is submitted that argument is not yet been concluded. Since the Learned Counsel for the appellant is not producing the certified copy of the order sheet, let a status report be called for from the Learned Trial Court. And while submitting status report, the Learned Trial Court shall specifically indicate as to why there is delay, if any, for the argument and for pronouncing the judgment.
The next date is 27th of February.
And it is stated, the next date is post argument not in, next date is 27/2024. Report be called for, matter be listed in week commencing from 26th February 2024. Register judicial magave, है ना? Yes.
Week commencing on 26th.
Item 30.
30, 2024. Yes.
Item 33.
May I please, Your Lordship? In this case, the IA 2682 by 23 is for bail, my lord. In this case, my lord, the appellant has been convicted under section 20B IIC of the NDPS Act and has been sentenced to undergo RI for 10 years and to pay fine of rupees 1 lakh.
Right. What is the sentence you have already undergone?
My lord, I am in custody since 10th April 2022, my lord.
10th April 22.
22. My lord, the
1
fact,
year, some months.
my lord, the fact remains, my lord, I have filed the evidence copy of all the witnesses. There are total 4 witnesses. Out of 4 witnesses, PW1 is the independent witness who did not support the prosecution case. PW2 is the ASI of excise, and PW4 is the inspector of excise, who is the detection officer, who is the investigating officer, and he is also he was also in the charge of the Malkhana. The case is like this, my lord. I have a glance to the evidence of PW2 and 4, total non-compliance of section 55.
Those things are not to be considered here now.
ତାଙ୍କର କେସ୍ ହଉଛି ସନ୍ଧ୍ୟାବେଳେ ଜବତ କଲେ ଏକ୍ସାଇଜ ଅଫିସ କି ମାଲ ଗୁଡାକ ନେଇଗଲେ ଯୋଉ ନେଇଗଲେ ତାର ହେଡ ହଉଛନ୍ତି ନିଜେ ଇନ୍ସପେକ୍ଟର ଏକ୍ସାଇଜ ଯିଏ ଧଇଲେ ଆଉ ସିଲ୍ ଟାକୁ ଦେଇଦେଲେ ଏଏସଆଇ କି ଦେଇଦେଲେ ବ୍ରାସ ସିଲ୍।
Those are the things which is to be considered. I cannot now at the bail stage make all, because you are found guilty. So you have just completed 1 year and few months. So
the appellant was represented by State Defense Counsel, and during trial he has not filed any bail application either.
It's all right, but that is why I'm asking you that since when you are in, because of the case was instituted on 9/4/2022.
My lord.
So you are taken into custody, and 10/4/2022 means it is 1 year and maximum 9-10 months.
Short of 2 months.
Right.
For 2 years.
So now
amount of contraband ganja is 22 kg.
Whatever it may be, it's a commercial quantity.
My
There is no difference between 21, 22 and so on. So it is a commercial quantity. Once commercial quantity means bar has to be considered.
My lord.
So that bar is there, and so far as your contention that man who is the detection officer is also the investigating officer, that has been dealt with by the 5 judge bench decision, that cannot be a ground for acquittal.
No, my only ground before your lordship, section 55 not complied at all.
55 is not a mandatory provision to be complied with. This 42, etc., those things are, but 55 is not a ground that it's mandatory and non-compliant. But whatever it may be, that is to be considered at the appropriate stage. At this stage, I cannot give a finding to that effect, and so you wait, adjourn the matter. Yes, next.
Obligement.
In the meantime, deposition copies be supplied.
Okay, deposition copy to be supplied, stay realization of fine.
Obligement.
Item 34.
ଇଏ ଆଁ 26 ତାରିଖ ପୁରା ଆଜି 15 ତାରିଖ ହେଲା 26 ରେ ଆସିବ ଗୋଟେ ସପ୍ତାହ ତାଙ୍କୁ ଦିଆଯିବ ୟେସ୍ ନେକ୍ସଟ
Item 37.
My lord, the appellant did not surrender before the learned court below after the completion of an interim bail period. So I am not able to furnish
the learned counsel for the appellant submitted that after availing the interim bail period as per order dated so and so, the appellant has not surrendered. IA number so and so. This is an application for bail in view of the conduct of the petitioner in not complying with the interim bail order. I am not inclined to grant interim bail. Accordingly, IA stands dismissed. So far as stay realization of fine is concerned, it will be considered after the appellant is arrested. Right? Not surrender. The London, let a report be called for from the London trial court. That is so and so in so and so case number. What steps have been taken for apprehension of for arresting the appellant and also against the bailers. The report should be furnished to this court
my lord,
on or before 26th of February 2024. Copy of the order be communicated by the registered judicial to the London trial court. Yes.
My lord, as per my instruction, NBW has been issued against
We'll see that. Let it come.
Item 38.
That matter against discharge. Matter. No. My lord, is it in the list? No, my lord, 40. 40? 47, 48, my lord. 47, it's Manas Chand. But rest of the matter will come tomorrow. Yeah, I think Satya Prakash, Satya Mahanti. 45. 45, it is Bikas Ranjan Khila. Yes, that man. Okay, it will, all these matters will come tomorrow. My lord had already instructed us to give copies to our side. We have given copies. Slowly it has to come for final disposal. So this is a case where, my lord, it's a cooperative society of employees. Because the Mr. Patra is not there, Bhuya is not. Not on that. Whichever date, my lord, may kindly fix, it will be ultimately probably finally heard. No, it's all right. Let it come tomorrow. Are you not available tomorrow? Yes, I'm available. So all these matters from 41 onwards, it will come tomorrow. Yes. Okay. That's fine.
Tomorrow's.
Kuda?
Item 34 tomorrow's.
34 टा अर्जुन अपन नथिले सी आसीओ नेक्स्ट वीक आसीओ कहि दै छी बाकी जोडा को पडिलानी आजि काली के आसीओ ठीक अछि काल आर आसंदा सप्ताह को आसीओ 41 टू काली के आसीओ यस दी प्रॉब्लम